All right, let's get right into it. We're going to break down a topic that, honestly, is crucial for anyone who ever deals with the legal system. It's called civil contempt of court. Now, I know it sounds super formal and complicated, but trust me, understanding this can literally be the difference between a simple resolved issue and a full-blown legal nightmare.
So let's start with the big question, the one that kicks this whole thing off. A judge gives an order. Maybe you have to pay child support or turn over some business documents or even just stay away from someone. What happens if you just don't? You just ignore it. Are we talking a slap on the wrist, a sternly worded litter, or is it something way, way more serious?
And that quote right there, that's the whole ballgame. A court order is not a suggestion, it's not a friendly request, it is a command. Think about it. The entire justice system is built on the idea that a judge's decision means something. Without the power to back up those commands, the whole system would just be a toothless tiger. So yeah, this idea is our first major point. The court's power to enforce its own orders isn't just some extra feature, it's fundamental. It's what makes sure a legal ruling isn't just an opinion written on a piece of paper, but something that has real, tangible force in the world. And that power, that's what we call contempt of court. So what exactly is contempt? Well, a lot of people hear that phrase and they think of someone, yelling at a judge in a movie. And yeah, that can be part of it, but it's much broader. It's really any action that willfully disobeys an order or just undermines the court's ability to do its job. This is called an inherent power, meaning it's not something politicians gave the courts. It's just part of the court's DNA, essential for it to function at all.
Okay, so once a court decides someone's ignoring an order and they need to do something about it, it comes to this massive fork in the road. It has to choose a path. Is this going to be treated as civil contempt or criminal contempt? And believe me, the path they choose changes everything. The goal, the rules, and how bad it can get for you.
And here it is. This is the single most important thing to understand. Civil contempt is coercive. Its only goal is to force you to do the thing you were supposed to do. It's all about the future. Criminal contempt, on the other hand, is punishive. It's there to punish you for what you already did wrong. It's all about the past. Coerce versus punish. That's the key.
Now, let's break that down even more. Look at this table. The goal of civil contempt is to help the other person in the case, to make you pay the money you owe them, for example. But the goal of criminal contempt is to defend the court's honor, basically. And because of that difference, the legal standards are worlds apart. For civil, the other side has to show clear and convincing evidence. But for criminal contempt, because you're facing punishment, maybe even jail, the bar is way higher. It's beyond a reasonable doubt. And you get all the same constitutional rights you get in any other criminal trial. That's a huge deal.
All right, so for the rest of this, we're going to focus on the civil side of things, because that's what most people encounter. So how does this actually play out? It's not like a judge just gets mad and throws you in jail. No, there's a very clear process. So let's go down the rabbit hole and look at the anatomy of a contempt hearing.
Step 1, it has to start with a crystal clear order. A judge can't hold you in contempt for violating something that was vague or confusing. Next, the person who's actually following the rules files a legal document asking the judge to order you to show up. Then, and this is super important, you have to be personally served with the paperwork. They can't just stick it in the mail. Someone has to physically hand it to you. And finally, you get your day in court, a hearing where both you and the other side get to tell your story to the judge.
So now you're at the hearing. And at this point, you're basically standing in front of two doors. Behind door number 1, there's a valid legal defense that could make this whole problem go away. But behind door number 2, well, that's where you find some pretty serious escalating consequences.
Okay, so what can you actually say to the judge? Well, the most common defense is, I couldn't do it. You can't pay money you just don't have. But, and this is a huge but, you can't just say, I'm broke. You have to prove it with bank statements, tax returns, the whole 9 yards. You could also argue the order itself was too confusing, or that you messed up by accident, or hey, maybe you followed most of it and made a good faith effort. But what happens if your defense doesn't work? What if the judge doesn't buy your story? Well, this is where the court's coercive power really comes out to play. A judge has a whole toolbox of things they can do to make you comply.
First up, they go for the wallet. A judge can order you to pay the other side's lawyer's fees for having to drag you to court in the first place. And they can hit you with what are called per diem fines. That's a fine that you have to pay for every single day that you're still not complying. Imagine a meter just running and running. That gets painful, and it gets painful fast. And oh, it doesn't stop there. Courts can get really creative.
They can freeze your bank account so you can't access your money. They can order property to be seized. They can even go after your driver's license or a professional license you need for your job. The whole point is to make your life so difficult and inconvenient that following the order becomes the easiest, most logical path forward.
Then that brings us to the ultimate sanction, the one everyone's afraid of: jail. But remember, in civil contempt, this isn't punishment, it's coercion. You're not given a sentence of, say, 30 days. You're put in jail until you do what the order says. The very second you agree to comply, the jail door swings open. And that's where we get this famous saying in the legal world: you hold the keys to your own jail cell. Your choice determines when you get out. Whew, okay, I know, that was a lot of heavy, kind of scary stuff. But here's the good news, and it's really good news. This entire situation, every single bit of it, is almost always avoidable. So let's shift gears and talk about the path to safety, what you can do to make sure you never even get close to a contempt hearing.
So here's your roadmap to staying out of trouble. First, document everything. Every payment, every email, every single attempt you make to follow the order, keep a record. Second, if you even think you're going to have a problem, tell your lawyer immediately. Don't wait. Be proactive. Third, and this should be obvious, if you get served with those papers, don't ignore them. Call a lawyer. And finally, just treat every single court order like it's a non-optional serious command. Because it is. At the end of the day, it really all comes down to this. The entire process of contempt of court is the system's backup plan. It's the enforcement tool that kicks in when respect for the court's authority breaks down. It's what makes sure justice is a real thing, not just a nice idea. The whole system is built on that foundation of respect. The only question left is, will you uphold your end?